we have to be very careful about it. There is a draft bill that I have had the sight of, prepared by the Ministry of Law, which has the effect of including Section 3A in our Alternative Dispute Resolution Act of 2017. And that schedule will list the laws or the types of cases that have to be mandatorily referred to mediation. We have to bear in mind that there are certain laws, like, for example, the rent restriction ordinances, for example, family laws, for example, suits on negotiable instruments, and so on and so forth, which require the courts to resolve them expeditiously. By making referrals of these disputes to mediation can have a counterproductive effect. It may take longer than it would have taken for the courts to decide. So we have to be very careful that mediation, instead of becoming a time-saving device, does not become a time-consuming device. But yes, the experiment of mandatory mediation can start off with fewer laws, because we do have a large number of accredited mediators as lawyers and in different other professions, but the number is not so large to deal with mandatory mediation. So this is something over which I would like to caution the Ministry of Law, that if you intend making a list, please do not make it very long, and do not make it such that has the effect of mediation becoming a time-consuming device. Thank you so much.
Pakistan is now leading the way in India and any other country in the world. I recall that in November 2022, I met Saath and Adil in Islamabad, and they thought of doing something for Pakistan to motivate and create a market of India and to develop an ecosystem of all 6 states which have all gathered today in this hall with you.
सुप्रीम कोर्ट के जस्टिस मियां गुल हसन औरंगजेब तकरीब से खिताब कर रहे हैं। तनाज़ात के हल के मुतबादिल निज़ाम के उन्वान पर सेमिनार का इनेकाद किया गया, जिससे उन्होंने खिताब किया। उनका कहना था कि तनाज़ात के हल के मुतबादिल निज़ाम को मजबूत करना वक्त का तकाजा है, और मज़ीद उन्होंने ये भी कहा कि हम ये चाहते हैं कि इंसाफ वक्त पर मिले, ताकि तनाज़ात का हल मुतबादिल निज़ाम की अहमियत इंतहाई अहमियत की हामिल है।
Commendable and appreciated by the entire world. We all started this journey together when we remember November 2023, when I gave the Delhi the first level of mandatory mediation, learning from the English Churchill judgment. That time, Islamabad High Court was ahead in setting up the Center for the ADR and bringing the in-house rules, regulations and notification. First, the High Court to do that, and then we started developing case law, and till now, you can see a booklet they prepared. Pakistan judges stand united, Pakistan judiciary stand together in relying on each other, forgiving each other, deferring each other for one cause, that's mediation, to overcome the backlog. The growth is substantial. We can see from the lens the prestige to Pakistan now, the confidence of the investor, bringing the capital to Pakistan, especially after this recent war. People think of coming to Pakistan in time frame of litigation. They think now we can see, with the help of Pakistan's all players, including Rahim and Farah, ODR, ADR, and all centers in the government of Pakistan backing. You can say that right now we have almost 20 centers. Every college is thinking of starting mediation and teaching mediation. Every judge has been trained as a mediator. Myself, we were in Singapore 2-3 years ago. The lawyers are prone now to mediation because only one reason. It will not take 2 years or 2 decades. It can take 1 hour, 2 hours, it can take 2 days. mediation successfully. If anybody wants to see the confidence on mediation, booklet is with everybody here. I've shared with them the judgments of the High Court and the recent judgment of the Supreme Court of the Mian Gul Hassan PLD 2025, Supreme Court page 499, relying on 25 Supreme Court page 1, 24 SCMR 947, 9 judgments of the Supreme Court, Lahore High Court. I also the judgment of Texas Upper to SPD, to Liberal and Morga Valley, to this judgment recently to Hotel Park. Their approaches of mediation. And mediation is only one side, the judiciary is doing it. We need 6 people. Center, which is, we are now addressing to this category of the launch of AITC. 2, the support is of the government signing the Singapore mediation in Pakistan is far ahead of countries ratifying that too. Then 3rd and the most important are lawyers and their willingness to sit with us. They prefer to sit down with the other lawyers and mediate a matter. And 4th and most important is the legislative and the parliament, which are always there to support. You can see today, on the Saturday, today, the Supreme Court judge is sitting with you on this cause, the Attorney General is sitting with you, the Law Secretary is sitting with you. Everybody is sitting together because we all are Pakistanis and we need to establish a confidence to the investor abroad. The World Bank ease of doing business, banking, Pakistan will improve. When we established the commercial courts in the Lahore High Court in 2020, did this follow the Chief Justice of Pakistan, the then Justice Absa, we had to say that we need to improve our ranking to invest because of the questionnaire they're asking the delay in litigation. ADR is the fastest route, and when myself and Justice Mian Gul was in Singapore, George Din, the guru of the mediation, who sat and taught us, told that we were like two foreign arbitration lawyers. Jahangir also says that, but finally when they went towards mediation, it's quick fix. One day to settle billions of rupees. The Chief Justice of UK, Lady Suker, that day made a speech of saying that 20 billion pounds a year they are now saving for business community only through mediation, and 200 billion they have saved so far in the last 10 years on mediation. I can proudly say you have the judgment reported in CID 2023 till 2026. You can read the judgment under mediation, but every judge, including myself, we do mention the amount the companies or the parties will be saving to mediate a matter. If you count those judgments and count the amount, I calculated it's almost 60 billion rupees so far. Even the Saath Poultry case 2025 CID 1200 mentions the amount and the workers out of job, there is no mediation. There are ways to do mediation. One is mandatory mediation, very successful. Secondly, court managed mediation. Court itself gives 1 week to parties for reality check. And third, most important, is early neutral party valuation, which I mentioned in the Netherlands, like the London Commercial Court, that when the case comes to a court can ask parties that we have evaluated the case. You can do facilitated mediation, or you can have the evaluative mediation. Fourth is a very successful approach which we did is having them sit together in a board meeting. This was a good formula where they were not mediating, one mediation failed. So I asked the parties to sit down in the board extraordinary general meeting. And when they sat on the board meeting for hours, they came out by settling that. This is another clause of the London Commercial Court guide, because London Commercial Court and London High Court Commercial Court has a prestige in the world. 80% litigation is out of English parties or foreigners. They have the confidence, that's called SEP, that is speedy, effective, trusted courts, and speedy, effective, trusted mechanism. They have developed this almost 100 years ago. They have the Commercial Code Guide, and Commercial Code Guide very clearly states one thing to start with is case management plan, case management conference. Sometimes the parties come to you in a huge matter. You always say counsel.
तनाज़ात के हल्के मुतबादिल निज़ाम के उन्वान पर सेमिनार का इनेकाद किया गया है, जिसे जस्टिस जवाद हसन खिताब कर रहे हैं। उन्होंने कहा कि तनाज़ात का हल मुतबादिल निज़ाम के सस्ते और फौरी इंसाफ की फराहमी की बुनियाद है।
4 बजते ही सारे सिस्टम हैंग, दिमाग, मूड और ये दोस्त भी थोड़ा लैग कर रहा है। अभी बताती हूँ। Nescafe cold, cold, cold. Coffee